Okay,
There we go.
we
All
are
right.
recording.
Very good. Well, Marley, should we get going?
Sure.
Yeah.
Sure.
Okay. Well, I will just start, I guess, and just welcome you to our fourth class that we've offered this year. We've done 1031 exchanges, we've done inspection classes, we've done credit classes, although I think we postponed that one. Yeah, we postponed that one. And then this will be our fourth one of estate planning. So it looks like we have a few other people joining. So welcome to our class, the Bramble Lane team. We like to give our clients as much information as possible. And because I'm going through this right now with the whole estate planning thing, we thought this would be a great opportunity to show some of our clients how to protect their assets and their estate. So I would like to welcome Mr. John Hill. He's an attorney at law specializing in this. And yeah, anything you want to add, Marley, or?
No, just thank you, John, for being here.
Yeah.
We really appreciate it.
Yeah.
Oh, sure. Well,
Take it away.
I'm glad to be here, and I am going to start sharing a screen. I have a short presentation that let's see if that starts sharing. Okay.
We can see it.
You can see it?
Yeah.
Okay, perfect. Oh dear, now how do I, okay. How do I go back? It's like, there. Let me go back to me. Okay. Again, John Hill. I've been doing estate planning now for 30 years in Salt Lake City, so I've seen a lot and helped a lot of clients. It's only the inspiration of those who die that make those who live realize what constitutes a useful life. Your peace of mind and lives of your heirs can be enhanced by planning, or they can be shattered. It's not merely planning for estate settlement, costs following death. Estate planning is a process, prudent financial planning, thoughtful personal planning, and it should be done constantly. As changes happen in your lives, you should be reviewing your estate plan. Yet 70% of the American public don't have even a simple will. So what constitutes estate planning? Well, it's a process by which you decide how to and whom your personal assets are to be distributed after your death. So a basic estate plan includes a will or a trust, powers of attorney, a personal property distribution worksheet, and healthcare advance directives. Now, without a will, the state, not you, will decide how your assets will be distributed after death. Now, that sounds a little scary, but the state has a plan. I mean, it would say, if you die without a will, your spouse is in charge, or your children. And if you don't have children, then your parents. If you don't have parents, then your brother and sister. So it's not like there some draconian bureaucrats going to decide where your assets are going, but they do have a plan. But it's better if you have a will or a trust to protect your assets. A will is relatively inexpensive, and it helps you protect personal assets from estate and death taxes. Now, currently, estate taxes are, you can transfer without any estate taxes $14 million. So most people, it affects the 1%. And that isn't going to change in the Republicans' big, beautiful bill. They actually wrote it in that it is going to continue going up at a cost of living adjustment. There had been a provision that it was going to revert back to a 2018 number, but that isn't going to happen now. A will can be handwritten. You can write your own wishes and just make sure they get notarized. A will can be changed or modified. Now, a trust is very similar to a will. The one thing nice about a trust is it doesn't go through probate. With a will, if you have titled property like a house or rental properties, you have to go through probate, which in Utah is not a big deal, but it does open it. It is a personal, it is a public record. So people are going to come out of the woodwork when you probate a will to try to, oh, let me buy your property, da 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 da. So a trust keeps it out of the public eye. Again, you can make a trust revocable. You would only pick an irrevocable trust if you had more than $14 million, most likely. There could be other reasons, but generally, a revocable will, you can change. You can make additions, amendments, that kind of thing. It does escape probate. It does generally acquire attorneys, so it's a little more expensive up front, but you name your successor trustee and it becomes a seamless transition after your death. Trusts are also useful for family members with special needs, where you can protect assets from the state and also give them, keep them supported in that way. Now, there are ways to fund a trust. Most people do not need to fund a trust, but I would say real estate agents maybe could have, they might have a lot of real estate assets, might be a little cash poor, and so cash can be needed if you want to maybe carry on the business. So there are options for funding a trust, whole life insurance, term insurance, annuities. This can be used, again, long-term investment vehicles can provide guaranteed death benefits, premiums that don't change, a living benefit that becomes tax deferred. It can be a mandatory savings plan for some people. It also is great for small businesses because, again, the main reason a business fails is generally the death of the owner or of a key employee. So life insurance is an option for funding a buy-sell agreement. Partners own the policy and are the beneficiary of others' life. Whole life provided to key employees stick around longer and they watch the asset grow, that it can actually be a benefit for that key employee down the road. Term insurance is another option that could be used if you needed to fund the trust. Again, most people's trusts are simpler, and they, again, with this, you can transfer up to $14 million. That is probably an option more for someone who's trying to keep a business afloat or not wanting to sell properties after their death. Another aspect of estate planning is a power of attorney, which authorizes a trusted individual to make these financial decisions when you are unable to do so. You're still alive, but you might be, well, dementia's a growing concern, or you're just getting to where you don't want to manage your financials. So you use a power of attorney. And at your death, the power of attorney goes away, and then we look to the trust or the will to see how your assets are to be distributed. Power of attorneys can be general or specific, time specific or situational. They can be limited or have full powers. And again, you can pay bills, collect debts, manage assets with a power of attorney. Healthcare advance directives is another key aspect of an estate plan. Making your wishes known to family and physicians as to end of life decisions. Did you want heroic measures? Are you wishing to be resuscitated? And so forth. These are the aspects of an advance directive that are part of your healthcare advance directives. A living will doesn't play a big role in most people's lives because it's that rare instance when you are in a persistent vegetative state. And again, but these are all covered in a healthcare advance directive. A living will, again, is clear, convincing evidence of what you want, what your wishes are. And your healthcare proxy, you're going to name someone to represent you legally, should you be physically or mentally disabled. Again, Utah does have a proxy law that if you haven't given consent for treatment, the proxy law allows an attorney to make the decision, then a spouse, then parents. Again, the laws, but usually these things happen quickly. People have to make a decision on the fly. And too often, doctors ignore advance directives and listen to the most vocal family members. So it is very important to have healthcare advance directive and have them in your medical record so that your doctor knows what your wishes are. You might ask, do I need an attorney? Well, a living will forms are readily available. The state has a form that most hospital system, well, all hospital systems recognize. And so that can be easily found. Again, I do this kind of work. Attorneys would generally make this part of their estate plan. And again, making sure your family knows, your doctor knows what your wishes are by having them in your medical record. The pitfalls of estate planning: we fail to make a proper plan. We periodically fail to periodically revise it. I've seen it where the ex-wife is still listed as the beneficiary. I've seen families kind of split apart where the second wife becomes a trustee and writes out the family members of the owner of the trust, the original owner. So again, planning is critical. Flexibility is a beautiful aspect of the living trust. It's a great way to plan for retirement. And again, it's a good way to remember to share our wishes with our family members. When all is said and done, more is said than done. And nothing happens by itself. We need to take action. So I know these issues, they're sensitive, they're personal. People are nervous about facing their own mortality and are likely to procrastinate. But it is important to set up an estate plan and give you and your family members peace of mind. So, I mean, that's a quick overview of what an estate plan entails. If anyone had any key questions or any questions, I'm willing to answer them. Or if you want to contact me directly on a personal matter, I'm glad to consult with anyone and give them advice. And I will now stop sharing.
John, I had a question.
Okay.
I've been thinking about this because I've been doing the worksheet. And I'm curious if you're the person who makes your medical decisions, the successor trustee of your trust, I think there was one other category. Should that always be the same person, or does that make sense?
Well, I mean, it, in many people's situation, it is. If they are still in a marriage, for example, they generally will pick their spouse, or they might pick a child to who's bound to be the beneficiary, and that they are the trustee, the successor trustee, or the personal representative as well. Um, for example, when my mother was still alive, she was not I didn't have her as my healthcare advance director because she would not have followed my wishes, I don't think. She would have wanted to try anything to keep me alive. So, I mean, so it doesn't have to be. It generally is, I find. And usually a child, or you can have co-trustees, co-executors. So if a couple siblings, if there's multiple family members, I don't like for a successor trustee to have more than two trustees, because say there are 3 or 5 siblings, it can really screw things up if all of a sudden one of them says, no, we're not selling dad's house. I think we should rent it. Well, if all 4 of them are co-trustees or whatever, that house is not going to be sold because they're not going to sign. And so that can be a concern for picking multiple co-trustees, or something to think about.
Yeah, I just feel like it's a lot of pressure, for one person to decide to keep you alive, to decide not to, or to follow your trust. I don't know. I just feel like that's a lot of pressure. That's why I was just curious what a lot of people do, but it makes sense if you have a spouse, or one child or something like that. So
Right. Well, and then, I mean, jokingly, you could say, if they're going to inherit a lot of money, maybe we do want to pull the plug.
yeah, very true, very true.
But
Maybe you can speak a little bit to real estate in particular.
okay, so this is where I like trusts. When you have a living trust, that you change the title of the deed to your properties to being owned by the trust and administered by you as the initial trustee, and then your successor trustees. And so the beauty of that is you always have control over the property, or your successor trustee does. So if you have a will and the property is in your name only, at your death, you now must go to court, because a title company is not going to transfer that property unless a judge has signed off on someone being the personal representative to take responsibility for closing, managing the estate, selling the properties. And they would be issued a letter of administration by the judge, and then the title company would transfer the property. So I've seen in the past where a family, the dad had a trust, and they have the house, they found the buyer, and then it turns out the house isn't in the trust. So either the attorney screwed up. I would blame the attorney first, that they didn't make sure that the trust was funded, because a trust is like a basket. If there's nothing in it, it does you no good. It's supposed to keep your assets. It's supposed to hold your assets for you. And that's why you want to make sure the bank account, the investment account, they are aspects and owned by the trust, with you as the trustee to manage them.
question
Yeah.
for you, John. You maybe answered this in that answer there, but my clients will often ask me if they need a trust, and I'll say, well, I can't really give you that advice, but it becomes more important if, and I'll start to say, you have wealth, you have special needs kids, you have, and I'll list some things. And I said, but in the end, that answer needs to come from a legal professional. You mentioned how much you like trust when it comes to real estate because it then takes an asset that perhaps lacks registration that's allowed to be sold without probate and allows that to happen. Would it be fair for me not to give legal advice, but to say to my clients, in general, if you own a home, it makes life a lot easier? Is it that simple that that's a qualifier that oftentimes will, in your case, would you often recommend someone fully consider trust just if they own a home?
Well, it depends on the situation. So for example, I had an 80-year-old come in. They had a will, and there was their child was a joint tenant on the account. Their house was in their name only. And I suggested, instead of writing a trust and changing all this up, that they could do a transfer on death deed, which was a very simple. I drafted a deed that says upon his death, the child automatically inherits. And so that was a simple, I charged $100 for the deed. They paid $40 to get it recorded. His estate was in fine shape without a trust. He didn't need a trust.
Yeah.
And so you don't need a trust. I mean, but if you have multiple properties, I mean, again, you can do transfer on death deeds. I think those are becoming more popular. They weren't allowed up to like 5 years ago. So it is a relatively new thing, but it's a great way if you already have an estate plan in place, and maybe it's just, let's make sure that house is going to transfer without having to go to probate.
Okay, great. And to follow up on that, just so I can kind of listen as I am trying to keep people's affairs in order too, what would be the most common qualifiers you see where you say, oh, that's where I start to say, I need this person to know a trust is important in order for me to do what's best for them? What are the most common qualifiers that you would say make
Well,
you recommend a trust?
I mean, again, I think it can go either way. So I leave it up to the client. I like the trust because once we've set it up, everything is in the basket. And whereas with a will, just a simple will, you're going to probate. And now not everyone's as smart as Ashley and she did it herself on her dad's will. Most people are like, I wouldn't know what to do. And so it's going to be, well, like a $2,000 expense for a probate attorney generally. I mean, we'll be charging about that or more to have a will probated. So if they don't have anything in place, no will, no trust, I mean, I will lay it out. You can go either way. I'm a fan of the trust because it's seamless. You've set up your successor trustees. There's no public, no one sees what's going on. You transfer your properties according to your wishes. They get transferred according to your wishes. You can set up charities, all this, and you can do that in a will as well. So again, I give them that option because some people, well, I don't, a will works. A will can work. If you don't have a house, well, maybe then you don't need a trust either. You could do a simple will, have a joint tenant on your bank account or your investment account, and you're good to go.
Thanks.
I would have to say, Marley, you can back me up on this, is we have many less problems with selling properties if they're in a trust as opposed to a will as real estate agents, just because when it's in a trust, we know we have to get a copy of the trust. We know we have to find the people who can sign for that trust. And it seems to be a lot easier than when we've run up against, we don't really know who needs to sign. We don't really know who, I don't know. I probably am not explaining it very well, but I would say from that standpoint, we would probably run into less problems when it's in a trust.
Mhm.
Absolutely. And our escrow officers like us a lot better.
Yeah.
When there's a trust in place versus very vague instructions. So
Yeah.
absolutely. Yeah.
Yeah, absolutely.
I can see that. Yeah.
I wanted to know if when you create a trust, and let's say 3 years from creating the trust, you liquidate a property and you consolidate bank accounts. Are those things that need to be altered in the trust, or because they're gone, they're just gone and you don't have to do anything?
That's the answer. You don't have to do anything. If you sell the house or one of your assets, it's no longer in the trust.
Yeah. You don't
Um,
have to go in and change the trust
no,
for something like that.
no, because
Okay.
the trust again is just holding your assets.
Yeah.
It's going to say who's in charge when I die, and here's what here's how I want my assets
Yeah.
to be managed at my death.
Yeah.
And
Yeah.
so, yeah, if the bank account is gone,
It's
then
gone.
it's gone, and we don't worry about it.
Yeah.
The problem is the trust owner sets up another account and puts it in their name only. It's like,
Yeah.
now if
Yeah.
there's a lot of money in there, we got to go to probate because it's in their name only,
Yeah.
not in the trust. And I always have this little cheat sheet that said in bold, that it's like, this is the language you use to put an asset in the trust. If there's a title, a bank account, something with a deed, so that they remember you've got to fund the trust and make sure your assets are in the trust.
Mm-hmm. Mm-hmm.
I had an interesting situation that just came up, which I've never had before. So, couple had a trust, but they never funded it because they didn't really have any money. I don't know who suggested they get a trust, but they did. They never had a trust. They never funded it. The daughter was cleaning out, years ago, so ago, and said, "Well, what is this? This is no good." Shredded the trust. Turns out at the death of the spouse of the wife, she had a life insurance policy that was supposed to pay into the trust, and now the trust is gone. And it forced the action into a probate court because the situation, well, a judge was like, "Oh, okay, well, that's very clear. The insurance company has to pay out." But it sure became complicated because there really is just one trust that is signed. So people ask me, "Well, what happens if you die?" Me, the attorney, and it's like, I was just the whatever, the transaction attorney. I just drafted it. If you need to amend it, any attorney can do it. You can even amend it yourself. But you want to maintain, you want to make sure you know where that trust is, and your successor trustee should know it's on the cabinet. It's in this box. Da 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 da, kind of thing.
Is the trust recorded?
It is not in our state. It's not recorded at all with the state. So it really is a private document.
Wow.
Yeah.
So that being, that's kind of an interesting question because we'll see on properties, we'll see if it's recorded into a trust, right? But then we have to have our clients track that down, right? There's nowhere to find it other than whoever created the trust, correct?
Well, that's right. So for example, I have an electronic copy of the trust, but it's not the signed copy. I don't maintain a signed copy because there is only one original and official signed trust document. Um, Again, with a property, because I always say, well, look at your deed. How is it titled? And most people are like, I don't know where the deed is. But every county recorder has a copy. So you can give the county recorder the address of your property, and they will say, oh, it's titled in, and it could be in the trust. I've had people where it's like, oh, everything is in the trust already. No worries.
Mhm.
And it's an old trust, but that doesn't change anything. We'll just add an amendment, if maybe a beneficiary has passed away or something, but there's no reason to create a new trust or some will, because the trust is there, the properties are already in the trust, and that's another nice thing. I mean, that um, it does survive. I mean, it's a living document.
So in a trust, say you have multiple properties actually, right? Say you have property A, B, and C. Do you only have one trustee for the entire thing, or could you say this property shall be managed by kid A, property B goes by kid B, right? And property C.
Okay, you can do that. That's the beauty of a trust. You can write it however you want. Um, you don't even have to be fair. I mean, I have clients come in, it's like, well, I have to give them all an equal share. It's like, no, you don't. And the kids don't even have to know that they're not getting the same amount, because, just the successor trustee needs to know where the trust document is. And, and then could read, oh, the reading of the trust, so to speak. Oh, you get nothing, or whatever. It doesn't have to be fair. And yes, I've had a client where he didn't want, one of the properties is such a good rental, and he has one of his kids who's in charge. He's been assigned the role of being the manager of that property, and it's all spelled out in the trust. And so that everyone knows this property is staying in the trust.
And if you can't find the trust documents, what happens then?
Well, see, that's like this couple with
Mhm.
it would depend. Okay, so if like they, you would have to go to probate. All of a sudden, now if there's if the document is missing, because like you're saying, the title company wants to see that they either a certificate of trust or an affidavit of trust. Um, that says the successor trustee is so and so, and here are the primary aspects of the trust. So if the trust has gone missing and the drafting attorney is gone, then you would revert. And when I do an estate plan, there is also a will. It's called a pour over will. That means that it says, well, I have a trust and I meant to pour over anything that I forgot to put in the trust. The pour over will pours over everything into the trust. So if the will is present, it would probably list the same trustee, or in this case, a personal representative, and then they would take that to the court. And if if the will is with the trust, which I put it in a nice binder, if they've lost the binder, then you can go to court without a will, and a judge would say, you know, someone who is like a child or a family member will step up and say, I will be the personal representative. And generally it's a child, you know, that is going to be the beneficiary. And then in the probate document, it'll say, okay, who are who would be the natural beneficiaries of this trust? And then they could go through that process and have a judge appoint one of these family members as the personal representative.
I'm sure you've seen some pretty awesome family feuds.
Luckily, I don't see many of the feuds. I hope to try to, you know, help them avoid that.
Right.
Um,
So would you suggest with the actual trust, perhaps putting it in a safety deposit box?
you know, I'm not a big fan of safety deposit box because the keys go missing. People don't know, they forget they have a safety, or the kids don't know mom and dad have a safety deposit box. Um, you know, a fireproof
Safe.
box at the house. I'm, you know, more inclined to, you know, some people are very, whatever they are, very thorough and will get a digital copy of the trust, give it to their successor trustee or the kids, and then have the original document in a safety deposit box. You know, if they go through all those steps, they're going to know where the safety deposit, there will be a safe deposit box. I mean, they'll know where it is. But personally, I'm not a big fan of safety deposit boxes.
Okay. All right. And lastly, so for example, I know my parents have a trust. I don't know who the attorney was. I know it exists, right? But if something awful happened and my parents were gone tomorrow, what am I supposed to do?
Go through all their paperwork.
Right, go through their paper. So maybe before tomorrow, maybe you should call them up, see how they're doing, do a health check, and ask them where the trust document is located. But again, the other thing is, if the trust disappears, you go to probate, and it
Right.
isn't a hard process in Utah. I mentioned these kids whose dad died. They thought the trust that the house was in the trust. It wasn't. In Utah, I was able to get, in 2 days, I had the letter of administration. So the deal did not fall through. The court is very responsive if there is, you know, a need for urgency. And even if there isn't, they'll have you the letter of administration within the week. They are very responsive. So, you know, if it's a clear case, Marley, if you're like, you have 3 siblings now and the will is gone or the trust is gone, the court's going to give all 3 kids an equal share. So
My sister's not supposed to have anything, though.
that's right. So
Yeah, I think that's probably where the largest issues come in, is when siblings are fighting and everybody's fighting because the wishes were not, you know, clearly communicated in some form. So yeah, I mean, I would think that for our clients, that would be a huge thing.
Yeah, I mean, I've told people have asked upon purchasing, well, what should I do? What do I need to protect the property? And actually, I had some clients years ago who owned a bar and were always being very afraid of some legal action, right? And so they were very specific in putting their properties in a trust to avoid that.
okay, well, that does not avoid the liability. They own the trust. So any attorney is going to be able to, I mean, we're talking a slip and fall on, or over serving, you know, that kind of thing. they're going to be found. That trust does not protect them. If it's an irrevocable trust,
Mhm.
it would then the asset, they've literally given the asset away. An irrevocable trust, you are no longer the owner of the property. And then that would protect the property from a slip and fall or a lawsuit. But once if you are sued and there is a judgment against you, they're going to find your assets.
All right. I can't remember exactly how they had it set up, but I mean, the bar is no longer, and one of the two owners is no longer alive. So I'm not sure how they had that structured, but I was always curious about that. From what he had said was that if someone tried to sue them, the house would not be something that someone could go after. It wouldn't be figured into assets, I guess. So maybe it was irrevocable.
It could have been in someone else's name. They might have already transferred it to someone else, or again, that taking it out of their name. What would be the other way around that? I mean, because even an LLC, a lot of people like putting their properties in an LLC, but the LLC is generally owned by the trust. And so,
Mhm.
and if the LLC, so you're also a limited liability company is not going to protect the asset from a creditor. Because you can go and look at the division of corporations and see who owns the LLC. And then if it's the people they're suing, they have, it doesn't protect it. It might be a way to manage if you have multiple properties, but it doesn't protect you from a credit or a judgment.
A judgment. So Alicia was asking, maybe the bar was in an LLC, which actually it was. But how does that differ from assets owned by a trust?
So usually the LLC is going to be an asset of the trust, because you want down the road your successor trustee to be able to manage that LLC.
Okay.
So I will have a general assignment that has the LLC listed as an aspect of the trust, even though with the division of corporations, it will list someone else possibly as the managing partner.
These are questions I've had people ask me about too, John. I've never offered even a hint of advice on these topics, but it's interesting to hear more about the lack of protection a trust or LLC provide. Is the real answer then for protection and estate planning and protecting the family's estate? Is it really about liability insurance? Is it really about some other product than an estate planning product?
Well, it becomes an insurance product. I think just like you're saying, it is, yeah, that is a trust or a will. It doesn't shield your property from a legal judgment. It might add a layer, I mean, but they're easily, and back to the home, for example, the bar owner, they might lose the bar in a judgment, but there is a homestead exemption. The judge is not going to take their house away to satisfy the judgment. There might be a lien put on it, but they're not going to lose the house, because a judge doesn't want to make someone destitute.
Well, yeah, he was kind of paranoid about that, but that's okay. So what um so I have some clients who own they owned their home, they ended up buying a second home. The initial home is now a rental property. Um, do they would it be wise to put the rental property in an LLC that is then part of the trust?
I don't think it's necessary. I mean, why? I guess the question is, why would they want to do that? It's still owned by the same person.
Maybe tax reasons?
There,
Maybe.
you
No?
know, I don't think there's not really a tax advantage. I mean, maybe because an LLC is like a sole proprietorship.
Mhm.
It's not a corporation. If they were to maybe put it in a corporation, and I mean, but an LLC is not going to change their tax liability, as far as I understand.
So if they're running that rental property though as a business, right?
Okay,
They put the first house as an LLC because they're trying to run it like a business.
and they can do that, and then they can maybe pay themselves as the um, managing member. Um, but once they cash that check, it's a personal asset. I mean, it doesn't really change the nature of the property is still, if the LLC is owned by the family, by the trust, or, it's still, it's, you're just adding a layer. Again, I don't know why. I mean,
It's maybe not necessarily, I mean, maybe for tax purposes, like Ash said, but otherwise not, not,
I don't,
Yeah.
I'm not a big fan of just creating another layer when, it's still, you're renting, but that would be a good question for a tax attorney. I'm not a tax attorney.
right, right.
And business expense deductions, I mean, that if you're going to itemize, sure. But you can do that as an individual too. I mean, it's,
All right.
yeah.
Ash, should I have you be a executor on my LLC?
No, it's too much pressure.
Pressure.
Under pressure. Yeah. Well, that's awesome. Does anyone else have questions before we wrap it up? John, can you do you want to, I'll just send everybody his contact information. And yeah, if you don't mind sending me the recording, that would be awesome.
Sure.
And we'll put it on our YouTube channel.
Cool. Sure. Will do.
Thanks, Alicia. Thanks
Thank you,
for joining
Alicia.
us. Thanks, Cody.
Right. Yeah. Nice to see
Thanks,
you all, and
JD.
Thank
hope I
you.
was of some help.
Great. So we'll wrap it up. Thank you, John Hill. We appreciate your time.
Yes.
And yeah,
My
have a
pleasure.
wonderful evening.
All right. Thanks.
Thank
you.
you.
Bye.
Bye-bye.